Good morning, everyone, and welcome to today's webinar hosted by Better Business Bureau. I am Ellie Schmidt, Marketplace Manager at your local Better Business Bureau. Today, we have the opportunity to hear from Roseann Collins from Employer Services Outreach and Brent DeBeaumont, a wage, payment, and hour technical specialist, both of which who are with the Washington State Department of Labor and Industries. If you have any questions at any time throughout the presentation, please type them in the question section and the panelists or I will address them during the webinar. Now that all of that is out of the way, thank you all for joining us, and the presentation is now yours, Roseann.
Hi, thank you, Ellie, for having us. This is really great. We love this opportunity to work with the Better Business Bureau. You guys have been a great partner to us. Thank you very much. Today we're going to talk about L&I basics for business for the restaurant industry. A lot of restaurants are maybe family owned and they don't really have a degree in business. They just are really good cooks and they want to make people have really good meals. So it's really hard for them a lot of times to know all of the things they need to know about labor and industry. So we are here to talk a little bit about that. Today we're going to talk a little bit about L&I. We're going to talk about wage and hour laws. We're going to talk about workers' compensation reporting for the restaurant industry, some resources for safety for the restaurant industry, and some free resources that a lot of people don't even know that we offer at L&I that's going to help you have a safe business and manage your claims correctly. Whenever I go out and talk to the public, I always want to talk about L&I a little bit because I'm really proud of what we do at L&I. Our mission statement is keeping Washington safe and working, and we do this by five goals. Number one, and a lot of people know L&I for this, is make workplaces safe, which is what we do, and we do it very well. We have a lot of dedicated safety people who go out and help businesses with that. We have consultation, which we're going to talk a little bit about later. Our goal number two is help injured workers heal and return to work, which is what I'm kind of part of. I work in the workers' compensation part of labor and industry. So we handle all the workers' compensation in Washington State. And we want to get workers back to work as soon as possible. That not only helps the worker heal, but it also helps the businesses keep a valued partner. Number three is make it easy to do business with L&I. And when I go out and tell people that, a lot of people chuckle a little bit. You might be chuckling now. But we really do want to make it easy to do business with us. And we are always working to improve our processes to make it easier for business to do business with us and to help the employers and the workers of Washington State keep it safe and working. Goal number four is help honest workers, businesses, and providers by cracking down on the dishonest ones. We have a team of dedicated auditors that go out and if people are committing fraud, we want to know about it and we need your help with that. On our website, you can report anonymously or you can report by name, but let us know if you know people that are doing things wrong because it makes it unfair for all the other businesses and providers when they do that. So we want to know, so please help us with that. Goal number five is ensure L&I is an employer of choice. I am here to tell you it is. It's a great place to work. And everyone that works at L&I is very passionate about keeping Washington safe and working. And I think that's why a lot of us are here. So we're really proud of what we do. So that's our five goals. Today we're going to start off with Brent DeBeaumont from Employment Standards, and that's another part of labor and industry that maybe people aren't that familiar with, and they handle all the wage and hour laws in Washington State. So if you have questions, they have a dedicated staff that's here to help you with that. I'm going to turn it over to Brent right now.
Good morning. Like Roseann said, I am Brent DeBeaumont. I'm the Wage and Hour Technical Specialist with the Washington State Department of Labor and Industries Employment Standards Program. And I advise constituents, businesses, labor groups, anyone who has questions regarding wage and hour requirements in the state of Washington. So today I picked out several laws and regulations that are directly applicable to employers in the restaurant industries. And I would also like to clarify several key differences between state and federal laws in this area that trip a lot of small employers up. And then also throughout this presentation, I'll have some contact information for other wage and hour offices at the local, state, and federal level, as well as my contact information and the contact information of several of my colleagues in the agriculture and minor labor industry. So for a brief overview of what I'm going to discuss in the next 20 or 30 minutes, my department enforces the Wage Payment Act, and that gives L&I the authority to investigate allegations of noncompliance with basic wage and hour laws in the state of Washington. Ones that are directly applicable to the restaurant industry are minimum wage and overtime, deductions, service charges, tips, meal and rest breaks, as well as minor worker requirements. My program, like I mentioned, advises on wage and hour regulations in the state of Washington. About 90% of what we do is investigate complaints filed under the Wage Payment Act of 2006. And the Wage Payment Act gives employees the ability to file a complaint, whether the complaint is found to be in violation or not. And we have a dedicated staff of over 16 agents statewide that investigate over 5,000 complaints a year. And I believe in the fiscal year of 2015, those agents collected over $2.3 million in unpaid owed wages to Washington state employees. The wage payment requirements under the Wage Payment Act that my department has the authority to investigate are spelled out in front of you right now. So those are the requirement to pay minimum wage, overtime, agreed to wages, which are wages set by a statute, ordinance, or contract. We also have the authority to investigate unauthorized deductions during ongoing and final paychecks. And then we also have the authority to investigate allegations of not receiving final paychecks themselves. So to sort of start, the basic 101 level, as everyone is, I'm sure, aware, the federal minimum wage is lower than the state of Washington's. It is currently $7.25 an hour. However, the federal minimum wage is just a basement, and states are allowed to go higher, which Washington has. The current Washington minimum wage is $9.47. As you can see from the map, the states that are in green have higher minimum wages as of January 1st, 2016. Like I mentioned, Washington minimum wage, $9.47 an hour. It's the 4th or 5th highest in the nation. And this applies to all Washington-based employees unless specifically exempted by the Act itself. So I'm not sure many people are aware, there are 16 categories of exempt employees under the Washington Minimum Wage Act. The citation is up if you want to reference those exempt employees. Also important to note, bona fide independent contractors are not considered employees for purposes of the Minimum Wage Act. Just calling someone an independent contractor is not determinative. We have a 6-part test that sort of determines whether or not independent contractor is truly independent. And our department, Employment Standards, is also tasked with calculating each year's minimum wage, which is published every September 30th by the Department of Labor and Industries. A couple weeks ago, we published the 2017 minimum wage, which is currently slated to be $9.53 an hour, an increase of 6 cents over this year's minimum wage. However, as I will discuss later on in the slideshow, there's an initiative that will be voted on 3 weeks from yesterday that could change that requirement. Also, I'm sure many people are aware, 3 cities in the state of Washington have passed minimum wages that are higher than the state level. And those are currently Tacoma, which is $10.35 an hour, Seattle, which has a 4-tiered minimum wage system based on larger small employers and the benefits that those employers offer. For more information, the citation, excuse me, the reference to the Seattle Office of Labor Standards, which advises and enforces that requirement, is on the screen. In the city of SeaTac, the highest minimum wage in the state is $15.20. Transportation employers within the city of SeaTac. Under the definition of hospitality employers is institutional, retail, or food service organizations, essentially food service organizations with a certain amount of full-time staff that are located within public facilities or hotels, I believe. The SeaTac Municipal Code 745 is also cited there if you want to look into that requirement a bit more. Also under the Wage Payment Act, under 4952.050, employment standards at the Department of Labor and Industries can enforce allegations of not paying these minimum wages. If you recall me stating a couple minutes earlier, agreed to wages set by a statute or ordinance can be enforced under the Wage Payment Act. Overtime in the state of Washington, pretty straightforward. It is 1.5 times the employee's regular rate of pay for each hour worked over 40 in a 7-day work week. The employer has the discretion to set that 7-day work week as long as it's not done retroactively to evade the requirements of overtime pay. In the state of Washington, it is not a requirement for daily overtime pay to be paid out. I understand the state of California has daily overtime for shifts worked beyond 8 hours in some situations. That is not a requirement in the state. Ours is based on 40 hours in a 7-day work week. Also important to note, it's 1.5 times the regular rate of pay. So for hourly employees, that's fairly simple. If employees pay $10 an hour, their overtime rate would be $15 an hour. However, it gets a little bit trickier when you have employees paid by hourly plus piece rate or salary plus commissions. For more details about how to compute that regular rate of pay to make sure you're paying the right overtime rate, we have pretty good administrative policies on that. It's ESA 8.1 and 8.2 on my department's website for a great resource to find out how to calculate that regular rate of pay. All right, so as I mentioned, there are specific exemptions to minimum wage and overtime that could be applicable to the restaurant industry. The one that's probably the most common is this executive exemption and the administrative exemption. And before I dive in a little bit further about the specific requirements for those exemptions, it's important to note that federal counterparts do exist to these exemptions, and they are more favorable to the employees. And where this happens, where there's differences between state and federal laws governing labor relations, or excuse me, wages, hours, and working conditions, the standard more favorable to the employee has to be abided by. So as you will see here, if you are paying employees pursuant to these exemptions under Washington state law, you might also have, or you would also have to abide by the federal counterparts, which require more payment to the employees. But I will explain that a little bit more in detail. So the executive exemption, in order for employees to be exempt from minimum wage and overtime, focus on the left-hand column here. These are the current state requirements. An employee must be paid a minimum salary of $250 per week. These were written and last amended in the 1970s. The primary duty is managing the enterprise or customarily recognized department or subdivision thereof, and regularly directs the work of 2 or more other employees. Like I mentioned, there are federal counterparts that are more favorable, and you notice that there's a strike through under $455 a week for the minimum salary requirement for the federal level. Effective December 1st of 2016, so about 6 or 7 weeks from now, an employee that makes over $455 a week and it otherwise meets the duties test is exempt from minimum wage. However, after December 1st, new federal rules go into effect, and that employee will have to be paid at least $913 a week to be exempt from minimum wage and overtime at the federal level. The state requirements are still $250 a week, so if you are automatically abiding by the federal requirements, you automatically abide by the minimum salary requirement for Washington State. There is some discussion of the State Department of Labor and Industries amending these rules, and that will likely be on the agenda for my department in 2017. If you would like to be notified about that, feel free to contact me. Contact information will be at the end of the slide. This is just a little bit more information about how to meet this executive exemption. The most common examples in the restaurant industry would be executive chefs and restaurant managers. Like I said, they would need to be paid on a salary basis and meet the duties test, over 50% of the time managing the enterprise or customarily recognized department, and directing the work of 2 or more other full-time employees or their equivalent. So essentially 4 part-time employees each 20 hours a week, if they were supervised by that executive chef on a salary basis, that executive chef will likely meet the duties requirement and be exempt from minimum wage and overtime. There's also the administrative exemption. It's similar, has the exact same minimum salary requirements to be exempt. Also has a duties test. Primary duty must consist of the performance of office or non-manual work directly related to management policies or general business operations of the employer, and the work must require exercise of discretion and independent judgment. This is, typical administrative positions. In the restaurant industry, this could be, for larger restaurants that have HR departments or payroll departments, the administrative exemption can be met through those sort of duties. Again, as long as the individual is paid the minimum salary requirement, which is important to note after December 1st at the federal level, that is nearly doubling from $455 a week to $913 a week. For detailed questions about what that means for you and your business, contact the United States Department of Labor Wage and Hour Division, as they are the federal agency that advises and enforces those rules. And this is essentially just an overview of everything that we just talked about, and U.S. Department of Labor Wage and Hour Division should be contacted for more detailed questions about the federal requirements. So for an issue that my department sees quite frequently from small businesses and the restaurant industries are unlawful deductions, especially during ongoing pay. And the laws that everyone needs to be aware of in this area are up there on the screen in front of you. RCW 49-52-060 and its administrative code 296-126-028. And essentially it sets out very narrow categories of legal deductions in the state of Washington. The first one are those deductions required by state or federal law. Workers' compensation is required in some situations by state law, and that would be an allowable deduction. There's also an allowance for medical, surgical, or hospital care or service. Deductions to satisfy court orders such as child support payments or wage garnishments. And then the one that triggers the violations most commonly for my department when we investigate is this last one here. When an employee expressly authorizes the deduction in writing and in advance for a lawful purpose for the benefit of the employee. So all of those criteria have to be met in order for that to be an allowable deduction. And this includes employee benefits such as retirement plans, payment to a creditor or third party, direct employee loans as long as the employer doesn't reap a profit off of those loans, and employee purchase of goods or services. And we get most of the violations, employees or employers that are unaware of this requirement try to take deductions for ongoing wages, for customer walkouts, cash shortages in a till, or the breakage of equipment. Such deductions during ongoing pay are never allowable. And if an employee were to file a wage complaint with my department would investigate the complaint and likely found that wages are owed. There are also further requirements here. The employer, like I mentioned a little bit earlier, may derive no financial benefit whatsoever from such deductions, and the deductions must be recorded openly and clearly in employee payroll records in order for the deductions to be lawful. And then there's also a category of deductions for final pay, and it sort of reiterates the requirements for deductions during ongoing pay at the top, required by state or federal law, hospital care service, wage attachment, or garnishment. And then if you note here, it has the same provisions for specifically agreed upon orally or in writing by the employee or employer. But here you're allowed to have deductions agreed upon orally instead of just in writing as during ongoing pay. However, there's a whole nother category for deductions from final pay that are more to the benefit of the employer. But none of these may reduce the employee's final gross wages below the state minimum wage. So if you have an employee that is paid minimum wage, you can never take deductions for this. If you have an employee that's paid higher than minimum wage, you can deduct between the difference, assuming all of the stipulations in A through D here are met. And this is how employers can legally recover for cash shortages or theft during final pay period. I'll concentrate on one just briefly. Let's look at D. Deductions taken due to alleged employee theft are permissible only if it can be shown that the employee's intent was to deprive and the employer filed a police report. So in situations where you have, on camera that an employee has taken money from the till, that basically proves the employee's intent. And then you need to file a police report. If you do so, you can take a deduction during the final pay period for that money in an attempt to recover. But a police report has to be filed, and if the employee filed a complaint with L&I, we would ask to see that police report in order to make sure that's an allowable deduction. Also important to know on the bottom, it's the employer's responsibility to prove the existence of any agreement, more applicable to the last slide with oral or written agreements to deduct, and those agreements should be recorded openly and clearly in the employee's payroll records. Directly applicable to the restaurant industry is service charges under RCW 4946.160. If a restaurant imposes an automatic service charge related to food, beverages, entertainment, or portage provided to a customer, the restaurant must disclose in an itemized receipt and in any menu provided to the customer the percentage of the automatic service charge that is paid or payable directly to the employee. And this is an area that not many people realize exists under our current state law. And I'll also discuss in a minute that this area could change under the Initiative 2. They have some specific language under Initiative 1433 regarding service charges. Service charges is also defined as a separately designated amount collected by employers from customers that is for services provided by employees. It's important to note that service charges are not synonymous with tips. And they cannot be used to offset an employer's obligation to pay the state required minimum wage. ESA 3 there is administrative policy that discusses that requirement a little bit further.
Brent, I have a quick question. This is Allie.
Absolutely.
About that last slide. If you are a customer that goes to a restaurant and you see that it isn't itemized out like you said it needs to be in this, what is something you could do as a consumer to, like, is there a way to report them, or is that something that the actual employee would have to report?
So yeah, there's limited enforcement that my department has over that specific provision of law. Private attorney would likely need to be consulted, or the consumer can raise to the attention of the employer that RCW and that they might not be in compliance with state law.
Okay, good to know. Thank you so much.
Yeah, not a problem. All right, nearing the end of my part of the presentation here, we have a specific regulatory code that states that gratuities received by employees shall not be considered part of the minimum wage, very similar to service charges not being allowed to offset the minimum wage. There are certain states that do allow tip credits. I know Idaho is one of them. Federal law does allow for tip credits as well. And it's also understanding that federal law contains more regulations regarding tips and how they have to be paid to employees. For more information about that, check fact sheet number 15, which is published by the United States Department of Labor. The City of Seattle also has some special rules here. For one part of their 4-tiered minimum wage for small employers, which are defined as employers that have 500 or less employees, I believe, they are allowed to have a minimum wage of $10.50 if they have at least $1.50 an hour on average for employee to receive in tips. And so if you have more questions about that, again, contact the Seattle Office of Labor Standards. When Seattle passed their own minimum wage, they also set up the Office of Labor Standards, and they have a dedicated staff that answers detailed questions about their minimum wage requirements. Finally, or next to finally, meal and rest periods. This applies to all non-agricultural employers. Essentially, the requirements for adults over the age of 18, the employees must be allowed a meal period of at least 30 minutes for each 5 hours of work. And those meal periods must be taken no less than 2 hours nor more than 5 hours from the beginning of a shift. Similarly, rest periods, the requirement is an employee is required to have 10 minutes of rest on the employer's time for each 4 hours of working time. And no employee shall be required to work more than 3 hours without a rest period. This comes from our administrative code 296.126.092, and we have a detailed administrative policy regarding frequently asked questions in the meal and rest period realm as well. If any restaurants out there employ minor workers, there are specific regulations to be made aware of. For workers under the age of 18, the business must obtain a minor work permit and keep specific information on file for each minor worker, which includes proof of age, employment description, and a valid parent school authorization form. Also important to note that there's maximum hours of work per day and week that minors can be employed at. And they also are subject to certain prohibitive duties and have special meal and rest break rules. For questions about these minor work requirements, I have the contact information of Josie Bryan. She is my department's child labor specialist, and she is very great with answering these questions. If you have any questions, feel free to shoot her an email or give her a call. And individuals under the age of 16 may also be paid 85% of the state minimum wage as well. So as I discussed briefly, Initiative 1433, which is on the ballot this November, which is, I guess, 3 weeks away now, would raise the minimum wage to $11 in 2017 and then gradually increase it to max out at $13.50 in 2020. And then it will be tied to the Consumer Price Index for urban wage earners for year 2021 and beyond, which is the same way that we calculate minimum wage currently at L&I. It applies to the same categories of employees and employers that the current minimum wage statute applies to. But this is a brand new requirement potentially if the initiative passes under state law. It would require employers to provide paid sick leave effective January 1st, 2018. Again, this is all hypothetical, but it's something to be aware of. I would, pay attention to the news closely after the election, and then also L&I's website regarding any requirements that may change should this initiative pass. And here's my contact information. Feel free to shoot me an email or give me a call whenever questions arise in the workplace. And now I'll turn it back over to Roseann.
Thank you, Brent. That was really a lot of great information. I hope everybody enjoyed that. I am Roseann Collins, and I work for Workers' Compensation Employer Services, and I work on the workers' compensation side. So I am going to today talk about some reporting issues that are common in the restaurant industry and how you can save money on your workers' compensation, because everybody wants to know that. So I hope that I can give you some good information. The first question I always get when I go out and talk to people about workers' compensation is, what records do I need to keep? Because it is overwhelming for a small business to know which records they need to keep. So basically, I made this slide. For each worker, they need their name, their social security number, the date of employment, the risk class that they're reported in, the basis of pay. So is it Monday through Sunday, or is it Sunday through Saturday? That kind of information. And you need to stick to one and report that way all the time. Gross and net. We also need time records with days and hours worked, summary of hours worked each quarter, and the employee withholding, which is what Brent was talking about earlier. Risk classifications for restaurants are pretty easy. There's basically one risk class, which is 3905. The base rate is about 42 cents an hour, and in the payroll deduction for the employees is about 12 cents an hour, 13 cents an hour. Basically, anything that's like a restaurant or restaurant-ish is under there. There's different subclasses. There is food, drink, and candy vendors, commissaries, eating establishments, such as public lunch counters in stores, taverns, restaurants serving spirits or hard liquors, pizza parlors, fast foods and drive-ins, soft drink lounges, and espresso. So pretty much that covers a wide variety of restaurants. And a lot of people ask me, well, Roseann, I have people in the front of the house and people in the back of the house. Shouldn't there be two different rates for the different level of hazards? No, we take that into consideration when we come up with the rates for the risk classifications, and we want to make it easy for employers to report. So if you have a restaurant, pretty much you can report everybody in that 3905. and we want to make it really easy for you. And we take into consideration that it's more hazardous in the back of the house than in the front of the house. I did put caterers up there too, because a common question I get with restaurants is, well, I cater a little bit. If you cater a little bit, and you can have there's a multiple classification rule, so you have to be able to have a standalone business that does the catering. Then you would be you'd have the 2 risk classes in 3909. But if you're a caterer that does a little bit of restaurant, maybe have a table in the corner of your restaurant, you're going to report all those hours in the 3909. And I do get that question quite a bit when I go out and talk to people about restaurant classification. But if you are just a restaurant and cater a little bit, we're going to look at how much you cater and how big of a part of that business is. Because if you have a commercial kitchen, a big commercial kitchen, and people going out all the time, then you're going to be in the 3909. And that is quite a bit expensive, so that's why people ask that question. Clerical employees, we also do have 4904, which is clerical, which some restaurants might be able to get that risk class. And as you can see, it's quite lower. And that is for people that work in an office that's separated from the hazard of the business. It has to be walled off. And it's a standard exception class, and it has special reporting rules. So for the 4904, your clerical person has to only work clerical. She can't work clerical one day and go out and work in the restaurant the next. So it's really restrictive. If you have someone who works in the restaurant but then does clerical once a week or something, they're going to be reported in the 3905 or the 3909 if you're a caterer. So you can't split hours in 4904 at all. The employees deduction, one of the questions we always get is, well, gosh, you know, I haven't been taking any money out of the employee's paycheck. That's optional. You don't have to do that, but you can't go back and do it retroactively. So if you say, oh gosh, I just found out from Roseann that I can take money out of my payroll, you're going to go forward doing that and give your people notice. So I would not start until the next quarter. We talked about those base rates, and those are all base rates. So that's what people start off with. We call it a 1 when you're at 1. We have experience rating at Labor and Industry, and we do this for fairness and to encourage accident prevention. The way it works is we look at your safety record if you had claims. Store C in the example has had no claims. They're safe. So they have a 0.5. When we did the experience rating calculation, they came out safer than we expected. So their experience factor went down. So we multiply that base rate by 0.5 to figure out what their rates are. Store B, we found they had claims, so they weren't as safe. So they're at a 2.0. So we multiplied their base rate by that 2.0. And this, again, is really important because it's not fair for a business if I'm being safe and doing all I can and buying the right protective equipment for my people, and someone over here is not and not being safe, that they should pay the same rates. The way we do the experience calculation is we look at what the expected losses are and what your actual costs are for your claims. We do an experience rating calculation every year for you, and we look at a business that's doing what you do, reporting the hours that you report. What do we expect the losses to be? And we do expect losses. We know that people have accidents. We know that people go to the doctor. We know that people do dumb stuff sometimes and get hurt. And we don't want that, you know, we want to say this is what we expect. We then look at the actual cost. So we look at how many claims do you have? Are they medical only? Which if you only have medical only claims, you can even get a claim free discount, which we're going to talk about in a little bit. Or do you have PPDs, permanent partial disabilities? It was time loss paid, and that we weigh against your expected losses, and we do a comparison, and your experience rating either goes up or down based on your expected losses versus your actual losses. There are limits to ratings. There's a 25% rule. And the 25% rule, let's say you're a small business and you had somebody get seriously injured, hospitalized, was out of work for 6 months. Well, we know that if you're a small business, that's going to hit you really hard. So we do have your experience factor cannot go up more than 25% in the year. Unfortunately, it can go up 25% the next year and the next year, because when we do your experience rating calculation, we look at 3 years of data, 3 years of reporting, 3 years of claim cost. So that can kind of stick around for 3 years, because that 3 years is going to be in your rating calculation for that. I said earlier, medical only. If you're going to get hurt, the best way to get hurt is to have a medical only. Just go to the doctor, get fixed up, get a prescription, go back to work. Every medical only claim, we take off the first $2,760 for 2016. It will be changing in 2017. That is twice the average claim cost. So if you're getting medical onlys only, you can still have a claim-free discount, which we're going to talk about in a minute. But that's why it's really important to get them to go to the doctor as soon as possible, because if someone got hurt on Friday, didn't go to the doctor till Wednesday, well, when we go back and do that claim, it could already be time loss before they even go to the doctor, because they didn't go to work, they maybe just stayed home and they didn't go to the doctor. So, but we go back from the claim date. So it's really important to, if someone gets hurt, to send them to the doctor. I'm going to try and play this video for you. This is the claim-free discount information page on our website, www.lni.wa.gov, and this is the claim-free discount video kind of explaining it.
Roseann, since we're not able to hear the audio for this, what was
Oh, you can't hear it?
Yeah, that's okay though.
Okay.
But, what was the link that people could find this video at?
Hold on. Oh, it's www.lni.wa.gov/claim-free discount.
Okay, great. Fabulous.
Okay. So just go on. So it's really important to make sure that you are managing your claims properly. One of the biggest money cost for businesses in Washington State is sprains and strains that can be prevented. And most sprains and strains can be prevented by doing things the right way instead of taking on too much. 44 cents of every dollar that we pay out in workers' compensation is for a sprain or a strain. So it's very important that you're making sure that your folks are doing things the right way. They're lifting properly, their workstation is set up ergonomically, and a lot of people don't know how to do that. So one thing that we do have is free consultations from ergonomics. Rick Goggins is our ergonomist, and he can set you up with someone in your area that can come out and help you with that setup. Again, it's free if you're state fund. And I definitely want people to do this. I just got a stand-up, sit-down desk, and it's made a tremendous difference on how I feel at the end of the day, besides when I normally sit all day. Now I can sit and stand, and it's really made a big difference. And it is an investment that L&I is making because we know what sitting at a desk all day can do for you. And I'm sure in restaurants there are certain repetitive motions that really cause a lot of injuries. Back sprains and strains are 1 out of every six serious workplace injuries. So it's really important that you can get some help with this, and it's really great. Other links that I have pulled out of our A to Z safety topics, which is a wealth of information that has topics on everything safety. I'm sure I did not think of all the ones that would apply to a restaurant, so peruse that if you have time. But we do have Getting Started in Safety and Health, and that can help you with setting up your accident prevention program. There's templates in there for that. And the most frequent cited infraction that we write tickets for is not having an accident prevention program. And a lot of people think, oh, restaurants, it's not that dangerous. Well, it is really dangerous, and you need to have an accident prevention program and look for the hazards and try to prevent them before they happen. And that not only keeps your workers safe, but it also reduces your workers' compensation cost. There is a restaurant industry safety and health page, talks about the front of the house and the back of the house, and it has links for all of those, and it lets you kind of know what to do, where to look for hazards. There's a page on emergency eye washing, and there's also on OSHA 300 logs, which I know a lot of employers have questions about, because I get a lot of questions when I go out and talk to people, and I have to refer them to DOSH to help them with that. But it's really important to do things right, especially when it comes to OSHA. We also offer free consultation services if you are state fund. We have safety and health consultations, which can talk about how to have a safe workplace, help you spot hazards. They can help you write your APP. And the important thing is, and a lot of people are weary about calling L&I, and I totally understand that, but the consultation, there's no fines or penalties are going to be assessed. If they do find something, they're going to want you to fix it, but they don't assess any fines. And that's important to know, because a lot of people have worry about that. And honestly, if you have a consultation, the inspector is not going to come for a year. They're totally different lists that they work off of, so they're not going to be able to come out and talk to you for a year or inspect you on a pop-up visit. Unless there is a fatality or something that needs to be investigated, because there's some accidents that we do have to investigate by law. Sprains and strains ergonomics, we talked about a little bit. That like I said, they can help you with the movement and the body mechanics and the placement of the work tools. Risk management consultation, these are great people to have out. They can help you with your HR practices, your hiring policies. They can help you start your early return to work policies and program. They can also help explain the rates and claims analysis of your account. So they bring lots of data with them about your account. When are you having claims? How are you having them? How can you manage them better? So they're great folks to have out. Again, these are all free, and people pay a lot of money for these types of businesses to come out and talk to them, and we do it for free for you. So please take advantage of these. You can call your regional office. I did throw up the King County number just because that seems where most of the businesses are located. But they can help you with that. So what should you do when an injury occurs? The first thing I want to tell you to do is, and I said this earlier, is encourage the worker to seek medical care. It's really important for them to go to the doctor as soon as possible. You also want to report hospitalizations, amputations, loss of an eye, or fatalities immediately. There's 24 hours and 8-hour rules about that. So you can just call us and we'll do that. And we will come out and investigate those. But those are really important to make sure that you're reporting them correctly. Not correctly, timely. You also want to complete the employer report of accident. A lot of folks don't do this, and I don't understand that at all. That's your way of telling us your side of the story, what happened in the accident. And it is a no-fault insurance, so that's fine. But you know, maybe you know that they have an arm shoulder injury, but you know that they do bodybuilding, so maybe they pulled it doing bodybuilding. It's good to let the claims manager know that, and one of the ways you can do that is through the employer report of accident. Also, I have a lot of businesses, when I talk to them, say, oh, that's not my employee, I threw it in the garbage. Well, if you threw it in the garbage, we have no way of knowing that that is not your employee. It's also important to stay in contact with the worker and bring them back to work as soon as possible. One of the things I hear from employers is, oh no, I didn't talk to them. It's not a lawsuit. You should and can talk to the injured worker. Tell them that you want to come back to work. Tell them that it's important for them to get back to work as soon as possible. You miss them. They're important to you. The team needs them, because it's going to do something to you when you're home not feeling well, to know that you're needed somewhere, and that makes a long recovery shorter. And it's best to bring them back to light duty, and I'm going to tell you why in a couple slides. We also have retrospective ratings, and retrospective ratings is where you can earn back part of your premium. You have to join, and they look back retrospectively. A lot of people join with a group. I know there's the Restaurant Association, but there's other groups that take restaurants, and usually it's an industry kind of group, or you could join by yourself. But if you do better than we think you're going to do, your expected losses are better than we think, then you're going to get a refund. If they're not as good, then you might get an assessment. So it is a little bit of a gamble. But a lot of times when you join as in an association, they're going to help you with the safe workplace. They're going to help you with early return to work, and getting those injured workers back to work as soon as possible, and managing those claims. So there's an opportunity to get money back. If you want information on that, Retrospective Ratings phone number is on the slide. Finally, and this is my favorite part, is the stay at work reimbursements. Stay at work is financial incentives for medically approved light duty work, including 50% of the base wages up to $10,000 or for 66 days. And it's a 2-year period, so they'll help you pick the best 66 days where you're going to get the most money back. They will give you $1,000 for training. If the injured worker is maybe in the back of the house and they maybe have English as a second language, you want to put them up front because maybe they could host or hostess for a while. We're going to give you money to train them. They might need Rosetta Stone or something like that, or maybe you're going to have them get online and type up your safety plan. We can give you money to brush up on their Microsoft skills, whatever it takes. And that, and also if you need tools or equipment, let's say you need something to facilitate that light duty job. Maybe you need another computer because you only have one computer, but you're going to have them work on the safety program for 6 weeks while they recover. We will reimburse up to $2,500 for tools and equipment. You get to keep that equipment. How great is that? Let's say you have someone from the back of the house and they need clothing to work in the front of the house. We're going to reimburse up to $400 for that clothing. They get to keep the clothing, and that's per claim. So it's really a great program. And why we do this is we found that it's better for the worker, and they heal better when they are around their family, their work family, because we all know we have those work families, and they're better at that. It's going to help them get back to work. And also it's better for the employer because it helps you keep a valuable employee. Who do you contact for help? Account managers. If you have questions about your rates, your risk classes, or your reporting, you can call them. That's the general information line, but they will get you to your account manager if you don't know their number. The claims manager, you are a party of that claim. You can talk to the claims manager. You can talk to the provider for that matter, and I encourage that you do. Talk about the treatment, the benefits. When are they going to get back to work? When are they going to get to light duty? And you could call 1-800-LISTENS is the number that will get you to the claims floor. And again, we talked about the consultations. And call them if you need help with any of the things I talked about. We do really believe that we are here to help, and we want to help you. And we have a lot of great, passionate people that really care about the employers of Washington State. Are there any questions?
Thank you so much, Roseann. Anyone would like to submit a question to have Roseann answer on the material that she just covered, please send them into either the chat window or the question and answer window. That would be fabulous. Is there anything specifically, Roseann, you want to hit home about that you talked about?
Just, we are here to help. And I know people don't always think of that, of L&I. That's my personal mission statement, is to help employers understand that we are here to help.
Awesome. I know it's been very educational learning about all the different facets in which L&I actually has free resources and tools available to business owners, employees, entrepreneurs that maybe want to start their own business. There's an array of things that it seems like you guys are always there to help, or at least have a tool to help guide.
Yes, definitely. And my job as outreach is to help people know about that. So I really appreciate the opportunity to let the BBB customers know that.
Absolutely. Well, at this time, I think we'll just go ahead and conclude today's webinar. Thank you all for participating today, and thank you again to Roseann and Brent from the Washington State Department of Labor and Industries. It's great having you guys on here to share this great information. I hope you all have a great day. Please feel free to contact BBB with any further questions at 206-431-2227.